This is the project for Jacob,
Summer,
and Jennifer.
We wanted to add some fun to this project, so we added pictures of each of us for a better understanding of each person talking on their sections of this project. 1. The methods of logic seeks to extend legal principles in ways that preserve logical consistency. 2. The method of history adverse to the historical origins of the legal rule or concept. 3. The method of custom views social customs as helpful guides to community values and settled expectations. 4. The method of sociology looks to considerations of recent justice, utility, and social welfare.
Roe v. Wade. Justice Harry Blackmun, while discussing the case, mentioned many of Cardozo's methods. The method of philosophy, because while judges follow the laws and regulations, they interpret them for the communities to be in harmony and agreeable with the law. The methods of history, tradition, and sociology, because while they did respect that laws were in place from our past, we need to realize as society is changing, the interpretation of the laws are as well. While these justices ruled in favor of Roe, that does not mean they all personally agree with such a controversial topic as abortion. But they all agree in what the 14th Amendment is supposed to mean. Roe brought to light that she made a mistake and allowed herself to get pregnant, and that time has evolved in the fact that more unmarried women are becoming more independent and doing as they please rather than what society tells them.
Bowers v. Hardwick. Cases of the United States Supreme Court have long recognized that the Constitution embodies a promise that a certain private sphere of individual liberty will be kept largely beyond the reach of government. The case before us implicates both the decisional and the spatial aspects of the right to privacy. In Bowers v. Hardwick, the question is whether statutes conflict with the Constitution of the United States. One of the specific constitutional provisions is our understanding of privacy. The issues in this case interfere with constitutionally protected interests in privacy and freedom of intimate association. The sex or status of the persons who engage in the act is irrelevant as a matter of state law. Justice Blackmun's dissent states, "It is revolting to have no better reason for the rule of law than so it was laid down in the time of Henry IV. This is in line with the method of history." He also states, "It is still more revolting if the grounds upon which it was laid down have vanished long since, and the rule simply persists from blind imitation of the past. I believe we must analyze Respondent Hardwick's claim in the light of the values that underlie the constitutional right to privacy." The method of logic is iterated when Justice Blackmun states, "If that right means anything, it means that before Georgia can prosecute its citizens for making choices about the most intimate aspects of their lives, it must do more than assert that the choice they have made is an abominable crime not fit to be named among Christians. This case no more is about a fundamental right to engage in homosexual sodomy. Rather, this case is about the most comprehensive of rights, and that right is most valued by civilized men, namely the right to be let alone." The method of sociology is stated when Blackmun says, "It is not proper to deny individuals the right to decide for themselves whether to engage in particular forms of private consensual sexual activity. However, the court concludes that this case is valid essentially because the laws of many states still make such conduct illegal and have done so for a very long time."
Examples of Justice Blackmun's language in Roe v. Wade and Bowers v. Hardwick. Roe v. Wade. The method of logic. The right to privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. And the method of sociology. The deterrent that the state would impose upon the pregnant by denying the choice altogether is apparent.
Bowers v. Hardwick. The method of history. It is revolting to have no better reason for a rule of law than so it was laid down by the time of Henry IV. The method of logic. I believe we must analyze Respondent Hardwick's claim in the light of the values that underlie the constitutional right to privacy.
Obergefell v. Hodges. The justice's dissent denounces the methods of history, tradition, and sociology because, while they do follow history and tradition, they do not modernize them and bring them to be at an agreeable state with the United States. They think the history of the laws stating marriage is between one man and one woman is how they all should be. Examples of the justice's language used in Obergefell v. Hodges. Justice Thomas said, since well before 1787, liberty has been understood as freedom from government action, not entitlement to government benefits. The framers created our Constitution to preserve that understanding of liberty. Yet, the majority invokes our Constitution in the name of a liberty that the framers would not have recognized to the detriment of the liberty they sought to protect. Justice Scalia said, but we need not speculate. When the 14th Amendment was ratified in 1868, every state limited marriage to one man and one woman, and no one doubted the constitutionality of doing so. Justice Roberts said, although the policy arguments for extending marriage to same-sex couples may be compelling, the legal arguments for requiring such an extension are not. Justice Alito said, for today's majority, it does not matter that the right to same-sex marriage lacks deep roots or even that it is contrary to long-established tradition.
In Debs versus United States, Justice Holmes' majority opinion states that the verdict on the fourth count for obstructing and attempting to obstruct the recruiting service of the United States must be sustained. Therefore, it is less important to consider whether that upon the third count for causing and attempting to cause insubordination and in the military and naval forces is equally impregnable. The jury was instructed that for the purposes of the statute and the persons designated by the Espionage Act of May 18, 1917, registered and enrolled under it, and thus subject to be called into the active service, were a part of the military forces of the United States. The government presents a strong argument from the history of the statutes that the instruction was correct and in accordance with established legislative usage. We see no sufficient reason for differing from the conclusion, but think it unnecessary to discuss the question in detail.
Schenck v. U.S. Supreme Court unanimous decision. Justice Holmes admitted that in many places and in ordinary times, Schenck would have had a right to say everything that he said in his pamphlets. However, when he said that how far a person's freedom of speech extends depends on the circumstances. When a nation is at war, he said, many things that might be said in a time of peace are such a hindrance to its efforts that their utterance will not be endured so long as men fight, and that no court could regard them as protected by any constitutional right. During war, he thought, the government certainly has the power to prevent obstructions to recruitment. Therefore, it also has the power to punish someone who uses words that are proven to cause such obstructions. The question in every case, said Holmes, is whether the words are used in such circumstances and are of a nature as to create a clear and present danger that they will bring about a substantive evils that Congress has a right to prevent.
In Gitlow v. New York, Justice Holmes dissented. The dissenting opinion is that this judgment should be reversed. The general principle of free speech, it seems to me, must be taken to be included in the 14th Amendment in view of the scope that has been given to the word liberty as they're used, although perhaps it may be accepted with a somewhat larger latitude of interpretation than is allowed to Congress by the sweeping language that governs or ought to govern the laws of the U.S. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about substantive evils that the state has a right to prevent. If what I think of the correct test is applied, it is the manifest that there was no present danger of an attempt to overthrow the government by force on the part of the admittedly small minority who shared the defendant's views. Eloquence may set fire to reason, but whatever may be thought of the redundant discourse before us, it had no chance of starting a present conflagration. If in the long run the beliefs expressed in proletarian dictatorship are destined to be accepted by the dominant forces of the community, the only meaning of free speech is that they should be given their chance and have their way. If the publication of this document had been laid as an attempt to induce an uprising against government at once, and not at some indefinite time in the future, it would have presented a different question. The object would have been one with which the law might deal, subject to the doubt whether there was any danger that the publication could produce any result. But the indictment alleges the publication and nothing more. Justice Holmes' opinions in Debs v. U.S. and Schenck v. U.S. and Gitlow v. New York. The explanation is this. Justice Holmes of the Supreme Court of the United States wrote the majority opinions for both Schenck v. U.S. and Debs v. U.S. They are similar cases that involve the Espionage Act of 1917. The issue was whether or not the act hindered Schenck or Debs' First Amendment rights concerning the freedom of speech. The verdicts and sentences in both Schenck and Debs were sustained because the court deemed that there were no violations of the defendant's constitutional rights. However, in the case of Gitlow v. New York, Holmes said the dissenting opinion that the verdict should be reversed due to a perceived overreach of the government. The Gitlow case presented less of a threat to the safety of the U.S. in comparison to Schenck and Debs. These three cases help elucidate on the scope of the First Amendment's protection of free speech. They also establish the standard to which the state or federal government would be held accountable when it criminalized writing or speech.